the Tomboys and the Ku Klux Klan, and they had broken my glasses when I wasn't. They took my car for a joyride and broke my glasses. Very competent, Cedric Simpson. You can tell. I'm very intelligent. I have a GED. I got a GED in 2013 in 3 months. Evaluation for what? What's going on here? I have ADHD and PTSD. I'm perfectly fine. I'm not on Social Security. People fucked up.
Okay. At least I wasn't called the Illuminati. Court does call the case. People versus Joshua Wara.
Trevor Mabel for the people here.
We are ready in this matter. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Wara. Mr. Wara, state your name for the record.
Joshua Wara.
All right. And this is a date and time I had set preliminary examination in this matter. My understanding is you would like a forensic evaluation.
That is correct, Your Honor. Based on my conversations with Mr. Wara.
Forensic evaluation for what? What's going on here?
Based on my conversations with Mr. Wara, I believe that it is necessary.
Hey, I'm representing myself. What are my charges? What am I in here for? I'm representing myself. I don't need a barcode to represent myself. What am I in here for? What charges am I on here for? I don't need a forensic exam. I'm not mentally disabled. I have ADHD and PTSD. I'm perfectly fine. I'm not on Social Security.
Sir, you are before the court on a felony complaint that alleges that on or about, as I read to you before, October 15, 2025, location of South Main Street and East William Street in the city of Ann Arbor, Washtenaw County, state of Michigan, that you did fail to stop at the scene of an accident resulting in serious impairment or death. Individual.
The guy was perfectly fine.
That is a felony, punishable by up to 5 years incarceration and a $5,000 fine plus court costs. You do understand that, sir?
I understand that. Thank you, Mr.
Count 2 on that complaint alleges that on that same date and at that same location that you did commit a moving violation causing serious impairment of a bodily function. That's a misdemeanor, punishable by up to 93 days, $500 fine plus court costs. You understand that?
Yeah, I understand that.
All right. So that is what you are here for.
Mr. Simpson, I'd like to subpoena the camera footage from the mobile gas station there on North Main Street that I was at, or on South Main Street where I was at, over on South Main Street in Maynard. My car was parked there the whole time. I accidentally hit the guy. They hacked the light using an AI.
Sir, Mr. Warren, I'm going to suggest to you this. Refrain from saying anything, because anything you say can be used.
Oh, I know. They used an AI ethical hacking app, the Tomboys and the Ku Klux Klan, and they had broken my glasses when I wasn't. They took my car for a joyride and broke my glasses while I was at St. Joe's Hospital.
The Klan did?
Huh? Yeah, the Ku Klux Klan. You can subpoena video records, and I subpoena the security guards from St. Joe's Hospital, Trinity Hospital.
That's one of the reasons, sir. That's one of the reasons why you have an attorney. Did you let them know that?
No, I don't have an attorney. I told them I don't want anybody to represent. I said I'm representing myself. Yes.
Is that what you want to do?
Yes, I would like to do that.
Sure.
And I would like to subpoena the camera footage from mobile gas station.
Now knowing what the charges are, sir, that if you elect to represent yourself, you'll be held to the same standards as an attorney would regarding the rules of evidence and procedure in the courtroom.
Yes, Your Honor, I understand that.
And would not be shown any favoritism.
Yes, and I would like to subpoena my discovery packet, please.
If at some point in time you wish then to be represented by counsel, you need to make that request to the court.
Okay. I've tried calling the public defender's office, and I've tried to tell them I want to represent myself. And I've tried to subpoena my discovery packet, and they won't bring it to me. I need to subpoena my discovery packet for all cases available, please. And I would like, and I would like to also subpoena everybody's address in the MDOC that's involved in the Neuralink case through Secretary of State, phone numbers, text messages, and visual voicemail records. And I would like to subpoena the phone recordings, Securus GTL recordings from when I was in the MDOC at ARS and WCC pictures. And
sir, I have listened to you both through the last hearing and this hearing. So what I'm going to do at this point is I'm not going to relieve the public defenders, but I am concerned, while you have indicated to me that you don't need a forensic evaluation, the court, in listening to you, does believe that you would need a forensic evaluation.
No, I'm perfectly fine, Mr. Simpson.
For your own
I'm not on Social
and
Security.
preservation of your rights.
I'm not on Social Security. I'm over the age of 25. I'm not mentally disabled. I do not need a forensic.
And sir, here's the thing.
I do not
I
go
have
to the forensic center.
I have to, in terms of these proceedings, make sure that you are competent and
Oh, I'm very
knowingly-
competent, Cedric Simpson. You can tell. I'm very
Thank you,
intelligent.
sir.
I have a
You can
GED.
name
I
that
got a
he
GED in
judged
2013 in 3
Okay,
months.
all right.
I got a GED from Washington Community College Adult Transitions Program in less than 90 days in 2013. You can subpoena that record. If someone can get a GED in less than 5 months, I'm pretty sure they're competent. And I would like to
Well,
subpoena my GED from the
here,
Adult
then you
Transitions
can
Program
do
in
that.
2013
You
at
can-
Washington
you can
Community
draft a
College.
Subpoena. I will not relieve the public defender at this point, but I will consider certainly that once the.
Thank you. Yeah, that way, if
Forensic
you see I got a GED from
I
WCC in
am-
2013 in 3 months, you know I'm competent. You know what I'm saying? Thank you, Judge.
I am going to order a forensic evaluation. I will set a competency hearing just to make sure. I'm going to set that for January 29th, 2025,
January 29th.
a.m. I will sign an order to.
Can you give me a
that
PR
effect
bond,
at this
please,
time.
Judge?
I'm sorry,
Can I please, I would like to request a PR bond.
this time you can file a motion or somebody can file a motion before the court and I'll consider a written motion, but at this time I'm not going to change the bond in this case.
What is the bond?
Currently, your bond is set at $25,000 cash sure.
Do you have any, bail bondsman numbers, for me that I could get a hold of, please?
Sorry, don't
I'd
those
like to subpoena a
You
bail
can-
bondsman
you can
phone
check
number.
with the individuals at the jail. I'm sure they'll be more than happy to assist you in that regard. All right, so that you understand, I'm leaving the public defender on the case at this point.
No, I don't want a
Get the
public defender.
evaluation. I hear you, but I'm telling you what I'm doing. We will get the evaluation. I'd suggest that you be cooperative in that. You may be right, it'll come back competent, and then we can get this proceeding moving even quicker.
Not gonna come back, huh? Y'all gonna try to.
Before we go off the record,
Y'all corrupt as hell. Y'all fucked up, people. Y'all people fucked up. Y'all.
Okay, keep moving. All right, been a pleasure.
I'm Benjamin Franklin's son.
Me too.
I just want to.
Because Paris is lovely in this one.
I just want to address one thing, Your Honor, relating to the prosecutor's office's responsibility of providing discovery as we move forward in this case. The defendant, in attempting to represent himself at the PCC on Thursday last week, stated that he didn't need an attorney, he didn't want an attorney, and that he didn't need the discovery either, that he knew what was going on, and that he wasn't worried about having all the video prior to today's hearing, and we were prepared to proceed today. At the same time, under normal circumstances, we would be in the process of getting all of that video discovery to defense counsel that he referenced wanting today. He mentioned wanting the video at the intersection. My office is in the process of getting that, hopefully before the weekend. And I'm looking for permission to provide discovery to Mr. Brown's office on this file moving forward.
In response, Your Honor, as we are still on the case, I would ask that they provide discovery as they normally would.
And then if in January, depending on what happens, then certainly that information can be tendered either if he's going to represent himself, which he may be entitled to do, then the public defender can turn it over to the prosecutors we have in other cases can supply it directly to him.
Understood.
All right. Thank you. At least I wasn't called the Illuminati in this one. Well, that's also called a bunch. It was also called a bunch of other things, but that's okay. I'm good with that. I'm confident in me, so
You are in court because your attorney is late.
Okay, so we only take a record in this court when the judge tells you to? Is this a tactic on the court's part to attempt to wear out the defendant so they can't access their right to trial?
Oh. Stop interrupting me.
Well, we're not on the
Stop
record,
interrupting me.
right? I mean, we're not in
Stop
court. There's no record.
Interrupting me.
I mean, that's the reason I don't come to your court at 9, because I know in another court, something's gonna actually occur.
All right, has an acknowledgement of discovery been done because I don't have it in the court's file?
I have signed a few of them at this point,
All right. Has there been any new discovery?
not to my knowledge.
All right, so you can make sure that the acknowledgement of discovery, the state actually has it and the court hasn't, because it's not in the court's file. And Odyssey is doing things on its own. So I'm gonna have y'all come back tomorrow. You're not number one on the docket. There are a couple of cases that are ahead of you, so those cases may end up going for 4 years. We'll just see where we are, okay?
That's correct.
Respectfully, Your Honor, Mr. Rios always appears, always waits all day. This is impacting his employment. We would ask that if we're not likely to be called tomorrow, that we be released. Additionally, I have experts for this trial that we have attempted to bring in, but we never know, and because the case is older now, when we should bring those experts in. So I'm gonna have to approach the court and request additional funds for those experts if we're reset. So I would ask the court either to give us some preference tomorrow for trial, or if we can't do that, to release Mr. Rios so that he can go to work.
All right, be here exactly at 9:30, okay?
Okay, yes.
All right, I'll supposed to be here exactly at 9:30.
You understand? Now, Your Honor, respectfully, every time we come to court, we lose an entire day of work ourselves too. This is not typical of most of the courts in this county.
Oh, yeah, it is very typical.
It's not.
Yes, it is.
You can say that, Judge, but I practice in
And
the
say
courts.
And it very is typical, because every attorney that's here has a case that's set for jury trial. And this is what ends up happening. What ends up happening is I will allow people to go to civil cases to be out of county, and then their client is sitting here waiting for them. And for some reason, that's the court's fault. That's not the court's fault when attorneys are not showing up at 9 or whatever, and then they stroll in at 9:30 or 9:45. So what I'm telling you all, 9:30, see y'all at 9:30. Thank you. Coordinator will give you a reset form.
Understood. Your
All
Honor,
right,
I'm
thank
trying to make
you.
a record. I don't see the court reporter typing.
What?
Okay, so we only take a record in this court when the judge tells you to? The case was called.
No, the case wasn't called. When I call the case, I call it by the style of the case.
Okay.
All right? All right, so I'll see y'all at 9:30.
Judge, I have to ask you, is this a tactic on the court's part to attempt to wear out the defendant so they can't access their right to trial?
Oh. I find that when there is no proof and people are just throwing things out. Now, what I can tell you, and I'm sure your client is aware, sometimes when we end up coming to court, we come to court because there are discovery issues. Sometimes when you're in court, you are in court because your attorney is late. And when I say late, I mean that when a case is scheduled in this court and it's scheduled for 9 a.m. and attorneys go to different courts because they want to go to different courts first, it is not the court's fault that you're sitting here for 12 o'clock or 1:30 or coming back over break. Number one, I have a lunch break. And there was a point in time where I would not take a lunch break. And the reason why I wouldn't take a lunch break is because I said, you know what?
Make a record?
I've been a defense attorney. And when I was a defense attorney, what I would always do, I'm like, I have to be in like 5 courts. It would be nice if they could stagger their docket. And so sometimes I would be here, we wouldn't have a lunch break, and I would be here till 3 o'clock. And then you know what I discovered? When I would say that I want to be here till 3 o'clock, I'm working through lunch, other attorneys, you know what they would end up doing? Then they wouldn't show up in the morning. They would just show up at 1:30 or whatever, because they're like, oh, the judge is going to stay there. So I stopped doing that because I need a lunch break. And that's what happens.
So then my other question, I guess, is if you're not doing this to cause the hardship, it obviously causes on all the attorneys and the defendants. Are you doing this for the YouTube? Because we don't have a record, right? Except for the YouTube.
Yes, here's the thing. You're to be back tomorrow at 9:30. You
Yes.
understand?
Yes.
All right, thank you so much. And once you sign the reset form, you'll be here tomorrow. If somebody goes before you, somebody goes before you. Your counsel is well aware, or should be well aware, if he's been practicing in Bear County,
For almost
that
20
there
years.
are a lot of cases that are on the docket for jury trial. So for example, I had approximately 40 cases down for jury trial today. What ends up happening, sometimes people who are in custody take precedent because their cases are older
I'm
than
asking for a
yours.
record, by the way.
You understand? Because they're older than yours. So that's what happens. So then what
Rulings
ends
are
up
being made, there
happening,
should be a record, right?
excuse me, stop interrupting me.
Well, we're not on the
Stop
record,
interrupting me.
right? I mean, we're not in
Stop
court. if there's no record.
Interrupting me.
Sir, here's your reset form at 9:30.
So
what ends up happening, sir, is that people who are in custody, sometimes their cases take precedent. And the reason why it takes precedent is because their cases are older and because the jail is overcrowded. Now, as you may or may not be aware, I call the docket all the time at 9 a.m. And sometimes when I call the docket at 9 a.m., defense attorneys are not here. Your attorney knows when he has not been here at 9 a.m. And then you have to wait. And you
Judge,
need
you're
to
aware
be
that every
here.
court starts at 9.
And you need to
I have
be
other
here.
cases.
And you need to be here at 9. So when your attorney is somewhere at another court, you know what ends up happening? Your attorney has made the choice to have you sit here and go to another court before
Well,
coming
that's not
here.
exactly true,
You
because all of
understand?
those courts got
All right,
business
good luck to
accomplished.
you.
All
Thank
of us
you.
got
Thank you,
recalled
sir.
today,
Thank you,
right,
sir.
Judge? So, I mean, what did we accomplish?
Have a nice
today?
afternoon, sir.
I mean, that's the reason I don't come to your court at 9, because I know in another court,
Sir,
something's
here's your
gonna actually occur.
Sir,
And their courts of exactly the same.
sir, this way, sir.
Hi. All right. Mr. Guzman.
Yes.
All right. So before the interpreter came, and correct me if I'm wrong, your attorneys came forward to let me know that they just received a new indictment. Is that correct?
Yes, Your Honor.
All right. And so that indictment, excuse me,
I was doing what the court ordered me to do and checking on the discovery.
all right. So what ended up happening is your attorneys, the way people treat people, which I find very odd.